Hello, everyone. For the last part of Chapter 11, we'll be talking about a mixture of topics that are related to civil assessment. We're going to talk about employment discrimination first, and then we'll go into some other related topics. So employment discrimination and harassment is a pretty relevant topic and one that we might be called on to assess and testify about. So sexual discrimination or harassment is one of the things that could come into play here, but also age discrimination or racial discrimination. And we'll talk in much more detail about disability actually as well. This is Title VII of the Civil Rights Act. Some of you may be familiar with Title IX. This is in higher education, and this is similar but for the workforce. So basically, Title VII says you can't make an employment decision on the basis of race, sex, color, religion, or national origin. This is also related to the Equal Employment Opportunities Act, which established the Equal Employment Opportunity Commission, or EEOC. It's related to the Age Discrimination in Employment Act, which extends to older adults. So what we're looking at here are what are called protected classes of people. When we're looking at discrimination effects on a group or class of people, psychologists testify as experts here about research findings, and there are nationally known experts who might testify in these cases. And then we also look at discrimination treatment of the individual. And you can claim damages, just like in the personal injury cases we talked about in the previous video, but because of discrimination. Psychologists will do individual evaluations or expert testimony on the effects of discrimination in these particular cases. So in terms of the sequence, first, claims of discrimination have to be handled at the employer level. So you tell someone within the company if you feel comfortable and safe doing so. If there's an Office of Affirmative Action, you go there. A lot of places don't have that, so you would go to Human Resources. And these folks receive complaints about all kinds of inappropriate discriminatory behavior. There's a problem here, which is it relates to civil liberties. A person has the right to know who's complaining about them, which, as you could imagine, sometimes involves retaliation against the person who's reporting. So you're going to first try to get an informal resolution through your workplace, and if you can't do that, then you might instigate a formal inquiry. Then an administrative body, usually the EEOC, will have investigators and hearing officers get involved. You'll be asked to indicate what remedy you want, and then that goes to the judicial system, the federal court in this case. So employers have a duty to provide a workplace free from hostility, imitation, or insult. So you're not supposed to intimidate people, you're not supposed to insult them, you're not supposed to be hostile against them. If clear, tangible effects of discrimination, such as the lack of promotion, are shown, the employer is liable whether or not they know what's actually going on. In the absence of physical damages or evidence, then you can also have what's called a hostile work environment. In that situation, the plaintiff needs to show the employer knew what was going on and didn't do anything about it. This especially applies for sexual harassment, but other forms of harassment as well. A hostile work environment interferes with work performance and seriously affects the individual's psychological well-being. The Supreme Court has ruled it's enough to affect the person's job performance. And this is generally claimed when no tangible effects are evident. These are things like jokes, comments about dress, appearance. It's not necessarily clear and compelling standards here. Sometimes the court has said harassment is offensive even if it's to you and no one else. Sometimes they say you need to compare it to the average other person. Penalties and consequences for this are usually extreme. Workplaces, as a result, will try to create an environment with no opportunities for anyone to be offended or harassed. So they might put protections in place, such as having a general sensitivity training, so you recognize employer is actively doing something to avoid this. Having an office specifically designed and dedicated to handling these complaints. And then if an employee reports to higher-ups and it's not followed up on, that's where a problem is really in place. So how do psychologists get involved in these cases? At the general level, we can be experts on the effects of harassment and discrimination on individuals. We can also assess the individual and testify, as in personal injury cases, and we can do both. Usually, we will only do this after it goes to federal court, and then we will treat the person after the harassment occasionally. So issues that are raised here. Did the alleged offense occur? This is the first thing that the hearing body must decide. This is not the responsibility of the psychologist. This is the role of the determining body. If it did not occur or no evidence is presented, there's no case, the action is ended. And then if it did occur, then the issue of welcomeness is raised. So were you a victim or were you welcoming it? Were you a participant? This is difficult because you're assessing things like internal feelings, motives, and fears. If you can't demonstrate that it was unwelcome, then it's over. And psychologists can get involved at this step. And then you look at the effects of the events, and this is where psychologists definitely get involved. So you look at job performance. The EEOC can take care of things here. If someone missed a promotion or they have a loss of money due to not having a promotion. You can also look at the general personal emotional effects like anxiety or depression, and this person can get compensation for psychological damages, and then that would take place in court like any other personal injury case. There is a time frame here to establish cause and effect, and the eggshell effect applies here. Vulnerability does not excuse behaviors of others that aggravated previous conditions. So if this person was already an anxious person, that doesn't matter in the context of this. And then you have to project change. How lasting will these effects be, and what will this person need in the long run? So in terms of the process, it's not really any different than other forensic evaluations we've talked about. You want to get data by interviewing everyone relevant to the case. You want to observe them during the interviews. You want to get records of job performance, any previous therapy records if possible. You do psychological tests to get current functioning. As with other cases that we've talked about, the limitation is we often do not have a baseline to which to compare that. It's easier to get these cases ruled in the favor of the person reporting the harassment if they have current distress. Malingering is important here. You need to really determine the validity of the distress and maladjustment. And how they approach the test doesn't necessarily mean that they're approaching everything that way, so we kind of have to take it with a grain of salt. Now we're going to talk about disabilities, which are another form of discrimination. So the Americans with Disabilities Act of 1990 prevents employers from discriminating based on disabilities. And this was intended for the workplace. So once you're in the workplace, not necessarily hiring, promoting, firing. So you have to have accommodations for people, wheelchair ramps, handicap parking, access for the physically disabled, such as restrooms and elevators in multi-level buildings. Complaints are also made to the EEOC here, and if you don't like their decision, you can appeal to the federal court. Physical or mental disability is covered. However, just having a disorder isn't enough. You need to show impairment, that it adversely affects one or more major life activities. This needs to be documented and the severity and duration noted. There are some disorders that are excluded from the ADA. These include sexual disorders, impulse control disorders such as compulsive gabbling, kleptomania, pyromania, psychoactive substance abuse of illegal drugs. But however, this is covered if they are rehabilitated. Homosexuality and bisexuality are not considered disorders anymore. They used to be in the DSM, believe it or not. They are, however, covered separately under the EEOC. It does include personality disorders. These were not originally listed in the ADA, but the EEOC interpreted it later to include these disorders. You need to inform your employer that you have one of these and have record and verification of that disorder. Now, in terms of discrimination, we're talking about differential treatment from people without disabilities. So criteria for hiring or maintaining a job have to be relevant to that job. So if you say this person has to be able to lift 60 pounds, you need to show that that's actually relevant to the job. Could you do the job with your disability if these, unrelated things were not included in the job description? When public safety is at risk, there are very high standards, and there's not going to be exceptions for disabilities, essentially. If you can do it with reasonable accommodations, then the employer is required to retain you. So who pays for these accommodations? Where's the expense come from? The ADA is silent on this issue, so the EEOC and the courts have to decide. It's not clearly defined, and you don't have to anticipate every possible disability, but you do have to respond if someone that works for you has one of these. You often end up in federal court to get these cases settled otherwise, and they're usually going to be very demanding of employers. In terms of accommodation of mental disorders, you have to, if you provide insurance, you have to provide treatment. Many places also have what's called an employee assistance program, or EAP, where treatment is free now. And the person has to meet job requirements with accommodation. Now, how will psychologists get involved? They can get involved during the hiring process, especially, as we talked about before, police, but also EMTs, firefighters, those who work in nuclear power plants, airline pilots, air traffic controllers, etc. Often these will require a psychological evaluation as part of the hiring process. You test and determine if they have a mental disorder, and usually you can't conduct these evaluations until there's an offer of conditional employment. The employer does screening based on anything but the psych eval, and then you take the most qualified people and ask the psychologist to evaluate them. Essentially, you need evidence that it will interfere with their ability to do the job in order for anything psychological to negate hiring. We might also be involved in fitness for duty or return to work evals, as we talked about in the police chapter. We can talk about hostile work environment for the disabled, and this is the same as any of the other types of discrimination we already talked about. The evaluations, you have to be familiar with the standards and procedures. You can be expert or research, or you can address a particular case, and it's similar to other evaluations that we've talked about. So the next issue we're going to talk about is a little bit of a morbid one. It's something called a psychological autopsy. So a clinician may be called on to give an opinion about a deceased person's state of mind as it existed at a specific time before death. And these have been termed psychological autopsies. Most rely on information from two sources: interviews with third parties who knew the deceased and prior records. Reliability of psychological autopsies is probably low. It's hard to determine what somebody actually was thinking, feeling, right? How has testimony about psychological autopsies fared in court? In cases involving workers' comp claims and questions of whether insurance benefits should be paid, the courts have usually admitted psychological autopsy testimony. In criminal cases, or cases involving the question of whether the person had the mental capacity to execute a will, which we talked about before, the courts have been more reluctant to permit the testimony. Last issue we're going to talk about here is civil commitment and risk assessment. This is really important. I know that we've kind of danced around this issue, but we need to address it more head on. So all 50 states and Washington, D.C. have civil commitment laws that authorize the custody and restraint of persons who, as a result of their mental illness, are a danger to themselves or to others, or who are so gravely disabled that they cannot care for themselves. There are 4 types of commitment procedures. The first is emergency detention. This is the most common ways people are initially admitted to hospitals. Someone comes to their therapist or calls a hotline, something along these lines that says, I'm going to kill myself, I'm going to hurt someone else. can't commit that they will be safe. There's voluntary inpatient commitment. Someone might present at a facility or an ER saying, I harmed myself, I don't feel safe, and become committed that way. There's involuntary civil commitment, and that requires a court order. And then there's outpatient commitment, where the person would not be in a facility permanently, but would be required to attend outpatient therapy. Now, in terms of dangerousness and risk assessment, this is going to be pretty similar to what we talked about in criminal cases. The terms dangerous and dangerousness merge three distinct constructs. Risk factors, which are variables associated with the probability that violence or aggression will occur. Harm, which is the nature and severity of predicted and actual aggression. And risk level, the probability that the harm will occur. Clinicians who perform risk assessments try to predict which persons are and are not likely to behave violently in certain circumstances, give an estimate of risk for violence, and offer suggestions how to reduce the risks. As you can imagine, many factors make these risk assessments pretty difficult to do. Some reasons, the base rate of violence in some groups is low, so you're being asked to be predicting something that occurs pretty rarely, and that's difficult to do. The predictions have often been for long-term risk, which is much, much harder to prove than violent risk over a shorter period of time. So in order to be accurate here, clinicians should have information about a range of historical, personal, and environmental violence-related variables, have limitations on predictions for specific types of violent behaviors, and concentrate on appraising risk based on specific settings rather than on general settings. So that is the end of our discussion about civil commitment, civil risk, civil assessments of various types. I hope that you have enjoyed these things, and I look forward to seeing your responses to your assignments for this week.